Hi, my name's Wonu Sanda. I'm a senior associate at CM Murray, and I'm with my colleague David Fisher, who's a partner at CM Murray. And we are delighted to do this 10-minute talk on team moves. So we're going to keep it short and snappy, but we're going to try and deal with some of the common issues that we see come across our desks when we are dealing with potential and actual team moves. So to start off, David, what is a team move?
So some people might have this perception that when we talk about team move, we're talking about a really big group of people. But in reality, all we really need two people who are looking to do something together, to make a move together. In reality, in most cases that we look at, it's a slightly bigger group. Very often some senior people with a group of more junior people, but strictly speaking, just a couple of people together. There's a potential team move.
And then it's often, I guess, people who are either moving to a competitor or maybe starting up their own business, and both of those things can count as team moves as well. So it doesn't mean you just have to be going to the main competitor or second best competitor or whoever. You could also just be setting up your own business, and that could still constitute a team move. I think often we also get kind of questions around what people can legally do and what they can't do. And people tend to be surprised about the things that they can't do because they assume that they should be able to do things like speak to their colleagues about their future plans because it's concerning their own personal careers. And you can see why it might come as a surprise to them that sometimes there are legal risks involved and potential obligations that they might breach. So, I mean, one of the questions, we get asked around is people speaking to other colleagues an issue when you're dealing with team moves?
Clearly, anyone who's trying to plan a move with colleagues is going to want to be trying to talk to people. So it may be that you've got a leader of a group who's perhaps been approached or has approached, say, a competitor. Doesn't have to be, as you say, but and they're wanting to try to get a group of people together to make a move. The natural thing for a person to want to do is to go and speak to their colleagues, and usually in some sort of clandestine way, so conversations out of the workplace perhaps, or messages sent on personal phones, emails, whatever it might be, just trying to get someone's interest, either to see if people are keen to possibly make a move or to say that there's this opportunity afoot. So most individuals will think, yeah, that's perfectly fine, why can't I speak to my colleagues about this? Or alternatively, a couple of people who might just be sitting down and having a chat, talking about what their hopes for the future are, and realizing that actually there's something here. Maybe we can make something here, make a move together. So yeah, it's surprising to lots of individuals in that situation to realize that they could be in difficulty just by having those conversations and starting to take things forward from there. I mean, what sort of things do you typically advise people in that sort of situation?
I mean, we kind of have situations where you can even break it into two camps of people. Often you do have the more senior executives or employees who will often have more onerous obligations, and they might not be express obligations in their contracts. They might be implied fiduciary obligations, which are kind of more burdensome, and they mean that they have almost like a higher level of duty to their employer. So when it comes to team moves, when they want to, or if they decide that they want to speak to other colleagues, those sorts of obligations could be triggered and can get in the way because those obligations often require them to tell their employer when there is a potential team move or a risk to their employer's business happening. So often we'd have to advise around those areas, just people not quite appreciating initially that those are the high level obligations they might have, especially if they are sort of senior in their roles. But even sort of, more junior colleagues will often have confidentiality obligations, and those obligations can be easily breached in team move situations if people are talking to a prospective new employer, and they are sharing information, and they're sharing information amongst themselves, and it's not within the kind of ordinary course of business, then even their sort of express contractual obligations could be breached. Sometimes nowadays you might have express contractual obligations that require employees to kind of fess up or tell the employer when something is afoot as well. So even if you're not a senior employee, it just might be in your contract. And so often these are things that, you know, people don't realize until that stage when they're thinking about leaving. And often, you know, when you sign an employment contract, you sign it once, you don't look at it again, you put it in a drawer. So it's only when they come to these stages that it becomes obvious that there are potential obligations that they could breach by sort of talking to colleagues and often talking to clients, which can be another sort of big issue that we come across, people who feel kind of a proprietary ownership over their clients, and where we have to sort of explain that often the clients are owned by the employer, the old employer, and they've got to be careful around their obligations there too.
Certainly, the conversations amongst the group, and as you say, I mean, conversations with the new organisation, new potential organisation as well. Just someone passing on, even like possibly names of team members who might be interested in moving, bits of information about them that would possibly help the potential new employer to encourage them to make a move. All those little things that individuals often don't appreciate could be putting them in breach of confidentiality if they pass that information on.
And I think a good point to mention here as well, just sort of the remedies that could potentially be engaged, is even where there aren't sort of express breaches of post-termination restrictions, which we were going to come on and talk about, if there are breaches of obligations, express obligations, there is the potential for the employer to get sort of interim relief. They could get a springboard injunction if the team moves and takes, cuts out a big part of the business, and they get a sort of head start from breaches of their express obligations whilst they owe those obligations to the previous employer. There's a risk of that. There are risks of a kind of whole plethora of other sort of remedies around getting hold of devices, for example, delivery up of devices that might show that there's been some wrongdoing and breaches that have been going on, being required to disclose wrongdoing by order of a court, damages and just a sort of injunctive relief as well, to kind of enforce any post-termination restrictions that might exist, which we were going to come on and talk about. But those are kind of risk areas, I think, for individuals who might be involved in team moves to think about, as well as their potential new employer to think about. So coming on to the post-termination restrictions, David, I just thought it might be interesting to sort of discuss sort of common things that we see. First
thing I'd say is that it's surprising how often people come to us and they've looked at their restrictions, and they see that they're perhaps expressed as post-termination restraints, and think, oh, this is fine because I'm not intending to solicit anyone after I've left. But what they're actually doing is doing all the solicitation whilst they're still employed, and therefore in breach of all their ongoing obligations of good faith and fidelity to their current employer, potentially breach the fiduciary duties as well, where there are fiduciaries involved. So that's the first thing, that people look at them and misinterpret, if you like, or just not focus on the right time period that's in play here. But then when it comes to post-termination restraints and how that will affect what happens afterwards, then there may well be non-compete obligations, for instance, that are going to prevent the individuals from actually working in a competing business or setting up a competing business for some time after they've left, and possibly, of course, restrictions around soliciting or dealing with clients and customers. But also, we do see more and more restrictions that are sort of anti-team move restrictions, so specific restrictions that will say something like you can't go and work in another business if someone from your team or your department, and sometimes even more broadly drafted than that, has gone to work in that business within a recent period of time. So lots of employers, more and more employers, put those sorts of restrictions in place as extra protection against a team move. It remains to be seen how effective those types of restrictions are. I think they will clearly have to be drafted very tightly in order to be enforceable. Clearly, there will have to be some sort of interest to protect. The employer will say it's the stability of the workforce, but whether restrictions of that nature are strictly necessary, whether they go too far to protect the interest, is obviously very much debatable. But certainly for the employer, having restrictions like that in place might work as a bit of a deterrent, gives you something to negotiate with when you're faced with dealing with a team move. Very often, the problem for the employer losing the team is establishing there has been some sort of breach. Clearly, the employer is going to assume that a sizable group of people has been having internal discussions, plotting things, sharing information they shouldn't have been sharing, that they'll be aware of what everyone else is up to and fail to tell the employer all this is going on. But proving that is potentially quite difficult. Without some good evidence that that has happened, it could well leave the employer with no action to take. So lots of threats, lots of attempts to find things out, but very little evidence to go on. So potentially those anti-team move type restrictions could be a useful weapon for them to deploy.
I think it's been hard to see whether or not they would actually be upheld in the courts, but as you say, as a deterrent, if you've got a restriction that tells you can't join the same firm as colleagues who are also leaving within a particular period of time as you, then you might not want to be the one to test that yourself.
Yeah.
We did want to touch on legal representation, and in these situations you often have the old employer, you have the team that are leaving, and as I say, the potential categories of sort of leaders or senior people, and then more junior people if you have a bigger team, and then you have the new potential employer, and all of them might want their own legal representation for different reasons. So you might have the new employer who could potentially be implicated because the old employer might bring a claim for inducing breaches of the employee's contract. The team themselves at some point, and this is something we often consider, there could be conflicts of interest or conflicts, that arise between the group where their interests diverge. So you might have the senior leaders still keen to go, and the junior people might have been convinced by the employer to stay, at which point in time they might want some different representation. And then, as the sort of employer themselves, the original employer, will often have their own legal representation too. But it can cause a lot of sort of complexity, I guess, in dealing with matters like this. But it is definitely also something for all people involved in a team move to bear in mind, because it can be quite a movable feast at times. Sort of reassessing who should be acting for who, and whether or not people should be looking at getting new representation. And one point, I guess, to make as well is around that representation is often we do see indemnities come into play, whereby a new employer will indemnify employees who are potentially at risk of litigation for their legal fees. And again, they might have a say in the way that is all sort of arranged. David, have you got anything you kind of tend to see that you think might be, interesting key point for people to bear in mind?
For me, the key things are the new employer is going to want separate representation, ideally from the team of people that's moving, and then within the team, think about the main protagonists having separate representation, certainly from other individuals, perhaps more sort of junior group or the followers, if you like. The main issue being you want to avoid conflicts. So as you say, if there is any split in the group, potentially you can carry on each with their separate individual representation rather than the advisors having to drop out if there's a conflict at that point. Around indemnities, certainly the individuals are going to want some assurance from the employer, and most employers are happy to give a degree of assurance, very often around things like legal costs for the team to support them through the process. Maybe also they might express an interest in sort of covering sort of potential liabilities, but they want to be careful about that. I think, as you said earlier, not want to be seen to be inducing breach of contract by doing something like that. very often, we'll see some informal sort of assurances rather than full written indemnities, and then it's just a question really for the team as to whether they're happy with that and whether they think they've got enough protection, going into all of this against the costs that they might incur. A lot of things there to think about for the team. I think it's just important to get advice early on, really, isn't it? So many times we see people who've got into these situations, they're so far along through the situation, through the move, they've done things wrong naturally, because as we said at the start, they assume they can do all these things without really falling into any traps, and it's then a question of trying to sort of remedy what's sort of gone wrong along the way. So the more that can be done at the outset to get everything lined up properly, the better, really.
Completely agree. So thank you very much for listening to that 10-minute talk. We hope you picked up some interesting tidbits. And if you want any more advice or information about this area, do go to our website or contact either of us. And our contact details are on our website, www.cm-murray.com. Thanks for listening.
Thanks, William. Thanks, everyone.